Today, I want to talk about documents you should never sign without an attorney. The law does not care that you skimmed it, that you trusted someone else to explain it, that you got nervous and signed it fast. If you signed it, it's on you. Courts assume you read it, understood it, and agreed to every single word therein. So let's talk about the documents you should never sign without an attorney. Because once you sign it, it's pretty much game over, with very, very, very limited exception, which I'll tell you about as we get into it. Before I do get into it, I'll ask that you remember to hit the like button if you like my content. If you have not subscribed, please do so, because it really, really, really helps in helping me continue to bring content to you like this, and I really enjoy doing it. So let's get into it. Okay, up first is mandatory arbitration agreements. I could talk forever about these. These documents take your right to sue your employer in court away from you. They force you into a private arbitration where you get no jury, no public record, nothing. It's just one lawyer who gets to listen to your case and decide not only whether or not you win, but how much you win. Employers love arbitration because it keeps their mess quiet. It keeps it out of court. It is just, something. You get it done a lot faster, but you pretty much are very limited in terms of what you can get, because think about it. You just have one lawyer who is sitting there hearing your entire case. It might last a week long, just like a trial would. You present all the evidence, and then the other side presents their evidence as well. And then that one lawyer that the two parties decided or agreed to use as the arbitrator makes a decision. Again, they decide whether you win and how much you win. But I want you to think about something for a minute. You know who pays that lawyer to make the decision? Your employer. So, yeah, that's kind of a conflict of interest. If your employer is paying the arbitrator to conduct the proceeding, that it's just like a mini trial, but it's just private. No judge, no jury, no record, unless you pay tons of money to have a record made, which that usually doesn't happen. But in any event, and let me say this before I move on from that. If there is no record, then there is no appeal, because there's no record of what happened for the appellate court to even consider. So it's a mess. That really encourages people to do whatever they want to do during arbitration, because there's not going to be any record of it. And again, it costs thousands and thousands of dollars just to have the whole proceeding taken down by a court reporter. So there's that. There's so much opportunity for things to go wrong in arbitration. So anyway, there's that. But here's the thing I want to also say about this. Most employees don't have a choice. Most of the time, in order for you to get the job or even keep the job, you have to sign an arbitration agreement. So you join a company and you have all these onboarding documents and you're just signing away, because at that point you're happy. You don't know much about the company. You're just glad to have the job, and you're not really questioning anything. You're signing what they're telling you need to sign in order to start working there. Well, most of the time, to the extent there is an arbitration agreement, it's hidden in those documents, and you sign, and they, by law, have to make it conspicuous, and so you'll see all this bold print. But again, people still don't know what they're signing. So I say never sign an arbitration agreement without a lawyer reviewing it first, but only to the extent that you have a choice, which is usually not the case. I have seen cases where a company maybe did not have an arbitration agreement, and they had decided to fire someone, and they try to get them to sign an arbitration agreement at that point. Yeah, right. No. At that point, they've already told you you no longer have a job there, and there's no reason for you to sign. But let me tell you something that's really messed up. If the company did not have an arbitration agreement and you're working there, and they tell you in order to keep your job, because they're maybe renewing or they're updating their handbook and whatever, and they tell you that as part of that updating of the handbooks, you have to sign an arbitration agreement. If you don't sign, they can say, well, you don't get to keep your job. And that's perfectly legal. So anyway, arbitration agreements are like, you just hate them. But, to the extent that you have a choice And again, it's very rare that you do have a choice when it comes to arbitration agreements. But if you have a choice, don't sign it without a lawyer looking at it first. Number two, settlement agreements and releases. Now, if someone asks you to sign a release or a settlement agreement, usually the settlement agreement has a release clause contained in it. And that release says you give up all your rights to sue in a court of law, that you're going to take whatever it is they're offering you in exchange for signing the agreement, for giving up your rights. You sign that without a lawyer, that is just, with one exception I'll tell you about in just a minute, that's the end. That's the end. So most of the time you see a settlement agreement or a release for our purposes in the context of an employment separation. So they're telling you, you know what, you're fired, but we're willing to give you, you might say, 2 weeks pay. And when we give you this 2 weeks pay, then you need to sign this document so we can give you the 2 weeks pay. Well, when you sign that document, you're saying, all right, I'm not going to sue you for things that I know about now and things I might not even know about in the future that come up. So maybe a class action comes up a month after you leave. You can't be part of it because you signed a settlement agreement. You signed a settlement agreement that contained a release saying you're giving up all claims, whether known or unknown. So if you think there's any chance whatsoever that you might have a lawsuit against the company, then you really want to think long and hard before you sign the settlement agreement. Now, let me tell you about the one exception that I alluded to earlier. If you are 40 years old or older, age discrimination laws require your employer to give you time to review the document. They have to give you 21 days to consult with an attorney or whatever it is that you want to do with that 21 days. So they're required to give you time to think about it. Like I said, 21 days. In addition to that, even after you sign, you still have 7 days to change your mind. But this applies to people 40 and over. So people who might be able to bring an age discrimination claim. But if you are under 40, you sign, that's it. Game over. I still think that you should, whatever your age, 40, over 40, under 40, if to the extent you have an option. Now, if you're under 40, they can tell you, sign right now or we're taking it off the table. That's just a sad fact. They can do that. But so you don't have as much protection. But for people over 40, you do have that protection. But let me be clear. It doesn't mean that they will respect that and that they're going to look out for you. I have had so many people come to me over 40. They signed the release because the employer pressured them. It's like, you don't get this money if you don't sign this right now. And they'll come to me and say, I signed it. And I'll go, whatever. And that's the one case where I will challenge and win the fact that they were forced into signing it, because that's a violation of law for them to make you sign it over age of 40. So anyway, there's that. So to the extent you can, speak with an attorney before you sign any settlement agreement. So I do have to share with you one case that just blows my mind because, we're involving signing a settlement agreement without having a lawyer look at it first. Now, I had this case was not in the employment context. So there's not this extra protection if you're not in the employment context. So I had a client that I represented, and we were in the middle of a lawsuit. And the people we were suing had done business with him before and claimed that my client owed them money. And they said, you know what, we will settle this outstanding debt, but you need to sign this agreement first. Now, we're in the middle of a lawsuit. Instead of him talking to me first, they made him feel pressured. And this is just like, dude, you were going to be able to talk to me in 24 hours. So they pressured him into signing. He signed it. And the release that was contained in that settlement agreement was broad enough to dismiss the suit that we had going on at the time he signed. That blew my mind. I just could not believe he did that. There was nothing I could do to undo it because this was just a business transaction. I'm also a corporate attorney, and my client did that. So yeah, I'll never forget that. Anyway, don't sign without your lawyer reading it first, if you can do that. Number 3, severance agreements. And this is pretty much the same thing that I was just explaining. Severance agreement, again, is like in the employment context, they're saying, we'll give you X number of dollars if you sign this agreement. I'll also point out that with severance agreements, a lot of times they contain confidentiality clauses, non-disparagement clauses, and other things that you might not think about. So in addition to the other things I mentioned, make sure that you're looking out for those clauses because they can come back and haunt you later on. Number 4, non-compete agreements. One place I see this all the time, again, I'm also a business attorney, and so I represent a lot of doctors, and they get hurt by this all the time. So they have this non-compete agreement. They start working somewhere and they have a specialty, and the non-compete will say you can't practice in this area. If you leave before the end of the contract, you can't practice in your area of expertise for 2 years. I've had doctors who had to move in order to do the work that they are trained to do because of a non-compete agreement. So sometimes they're too broad and they're unenforceable, and sometimes not. So that's just one area where I see that a lot. But again, make sure you know what you're signing because sometimes even if they're not enforceable, an employer who has some gripe with you will send a letter to your new employer and threaten your new employer with a lawsuit saying you are interfering with this contract that I have with this person you just hired. Because the contract that we have together says that they can't go work for anyone else doing X, Y, and Z. And you are helping them to breach this contract. Now, whether or not it's enforceable, who wants to have a new employer having to deal with that? Non-compete agreements are notoriously broad, and a lot of times they're not enforceable in court, but just know what you're getting into when you're signing it. Number 5, non-disclosure agreements. Non-disclosure agreements are not always bad, but you should know exactly what you're agreeing not to talk about. I've seen some interesting non-disclosure agreements, in particular where celebrities are involved. I had one case, for example, where anybody who went to this celebrity's home, like at the entrance gate, were given an NDA to sign because they couldn't talk about anything that went on in the house. And that's all well and fine, except that one person who signed the NDA ended up having to sue that celebrity, and that was my client. And so the NDA kind of threatened the lawsuit. We ended up settling, but the NDA played a pivotal role in the lawsuit. So obviously the celebrity didn't want my client talking about what went on. My client needed to talk about it because that was part of the case. Again, it's settled, but non-disclosure agreements really it's kind of like a gag order. So just know what you're signing. Number 6, performance improvement plans, PIPs, that require signature. Now, you probably are going to have to sign it anyway, or even if you don't sign it, it's not going to stop you from being placed on the PIP. I bring this one up to say that you should not sign a PIP that seems to imply that you agree with everything they've stated. So the PIP should say that you're signing to acknowledge that you received it only and not because you agree with the things they've stated in the PIP. So to the extent that the PIP purports to have you agree with what they stated, then you should handwrite on the PIP that you are agreeing that you received a copy of it, but that you disagree with what they've stated therein. And that if necessary, you are happy to provide evidence at a later date if necessary. Plain and simple. Number 7, any contract with at will modifications, as in employment at will. So let me just say, people really misunderstand the employment at will doctrine all the time. Employment at will simply means that you don't have a contract that says the exact date when your employment ends. It can end at any time because you quit or because they fire you. That's what employment at will means. It has nothing to do with your rights. So they really cannot fire you for any reason at any time if the reason is illegal, discriminatory. It's, I think they put that on documents sometimes to intimidate employees, because most employees don't really understand the at-will employment doctrine. And so when they have that on the page and remind you of it at the end of your employment, sometimes it has the effect of chilling the employee from moving forward with any lawsuit. So just keep in mind, employment at will doesn't mean that you have no rights. Not at all. And finally, number 8, anything presented during a crisis moment. If they give you paperwork to sign during an emotional moment, as in you're emotional because they're firing you and you're upset, or right after they accuse you of something, right after you file a complaint or any of that, that document is not for your benefit. They're taking advantage of you. So slow down, take it home, get it reviewed. You'll be happy you did in the end. And the reason you need an attorney to review it is because legally, the fact that you didn't read it is not a defense. There's a saying in law, ignorance of the law is no defense, and this is right there along those same lines. The fact that somebody misinterpreted the contract, you just had a relative or somebody in HR, of all people, review it for you, it doesn't matter. It's up to you to know what you're signing, because the court is going to presume that you knew exactly what you were signing, that you knew exactly what you were getting into. So it makes sense to call an attorney before you do. One thing that drives me crazy is when an employee calls me after they've done something that I can't undo. If an employee calls me after they already quit, and then it's like, okay, now advise me. I hate that so much. Never quit before you talk to an attorney. It's just one phone call or however many phone calls is necessary. Even if you have to pay for a consultation, because if you call an attorney before you quit, that attorney might very well be able to negotiate a severance so that you get to walk away with money. If you quit first, you pretty much lose all leverage. And people love to say, well, what about constructive discharge? Let me tell you, I'm not gonna start talking about that too much because I hate it so much, and then I'll go on. That's a whole new video. But constructive discharge means that you quit because you felt like you had no choice. Good luck with that. Good luck with that. A judge is gonna look at that and go, yeah, right, because the standard of proof changes to no reasonable person no person in their right mind would have remained at the job under these circumstances. And so a judge is going to be looking at that, looking at your circumstances and saying, now, would a reasonable person have remained? What do you think he's going to say? That is so subjective. Never quit unless you talk to an attorney first, if at all possible. People say, but my mental health is more important. I get that. But does that stop you from contacting an attorney first? I mean, it is, even if you have to pay for a consultation. I don't do free consultations. I don't have enough time to spend time on the phone giving free consultations. But you can call me for a paid consultation, or you can, whoever, it doesn't matter, but at least know what you're getting into before you quit without signing. So I knew I was going to go off on a tangent when I started talking about constructive discharge. But anyway, these are the documents that you should not sign without an attorney reviewing them first. I'll see you on next shift.